that the subject that he most needed to be addressed was operating agreements. Um, and typically, operating agreements are used with LLCs. From my experience and with business attorneys that I talked to, um, by and large, the entity that's being formed is LLCs. 95% of what people set up for new businesses is LLCs. Um, really, the only other option is to set up a corporation. It could be an S corp or a C corp, and we do recommend that for um, people who are looking for um, funding and looking for a quick exit. But otherwise, an LLC seems to be the easiest. It has less formality. You don't have all the corporate requirements for it, and you can have an operating agreement for a corporation. I know of one of those, but generally, it's dealt with more by stock agreements and agreements between the uh, parties and the board and bylaws and things like that. So we're really pretty much focusing on LLCs here. Uh, Let me pop up another slide. Who needs an LLC? Or excuse me, who needs an operating agreement? We could talk about who needs an LLC too. Um, One of the things we found with the um, student ventures is sometimes there's a rush to to form an LLC. Um, we need to think about, are they really in their final form? What we have seen in a lot of these situations is starts out with maybe a team that's there for a pitch contest or something like that, and then um, some of the people fall away, and it's very common. Some will stick with the business, and some will lose interest and go gravitate to other things in their studies and so forth. So there is to some degree an issue of when do you form the LLC. Lawyers want an LLC quickly. We're afraid of risk and liability and exposure, and it's good to have LLC. It gives structure to the business. It also gives you some credibility. It shows, have you gone through the legal formalities of forming a business with the Secretary of State. And then you come to the next question: who needs an LLC? Or excuse me, I keep saying that. Who needs an operating agreement? Um, and single member LLCs generally do not. Um, Sometimes we've come up across a couple of banks to open a business account that want an operating agreement. That's sort of on their checklist of things for a new business client. And we've given them one. It's about 3 or 4 pages. It's very simple. You really don't need a lot to define the relationship between the member and the business because they're almost, one and the same. Uh, with multi-member LLCs, we strongly recommend it, an operating agreement. Um, Under our setup in Ohio, under the Ohio Revised Code, it recognizes operating agreements, and you can deviate from the standards of the statutes by having an operating agreement. And an operating agreement is nothing more than a written contract between the members. And that's what we call the folks within a LLC. There are members. And it's just them setting their own rules, and the revised code allows them to do that. They can reach their own agreement on most, pretty much all subjects. So we do recommend it for them. Here are some of the subjects that an operating agreement would address. Individual roles, what the individuals are going to do within the organization. A lot of times we don't put that in because they may change, they may pivot to different roles. But sometimes we do want to sort of lock down the territory that each is going to be involved with. Some may be passive, some may be involved with marketing, some may be involved with tech development, different things like that. So we might set out the individual roles. Usually we define voting and what needs to be voted upon, and what needs to be by a majority vote, what needs to be unanimous. We also deal with distributions. How are the profits, if there are some, are going to be distributed? How can the interest be transferred? When will there be dissolution? It avoids the statutory default rules and lets them set their own rules. Yeah, and particularly on the transfer of interest and dissolution, sometimes I've heard operating agreements talked about as a prenuptial agreement for businesses. And that's a major role of it. It's a prenup. How are we going to split this up if things go awry or if things don't develop as we want? How does somebody leave? Particularly in dealing with students. They may, while they're in college, they're going to be part of this organization, but then they're going to move to Idaho and open a potato farm upon graduation. Who knows what they're going to do? So, we need to deal with what happens to their interest, how it's going to be valued if they want to leave, how it's going to be paid out, all these things. So some of the key components are the purpose and powers of the purpose of the LLC and the powers of the members. What membership means, how the LLC is going to be managed, sort of the economics and the ownership of it, and what happens upon dissolution. So these are all key components. Some people have asked us, we just want a template. Just give us an operating agreement to fill in. Well, the problem is one size doesn't fit all, and no lawyer would do that to sort of say, oh, you fill in your own. We try to do a custom product and seed, and that's what most law firms would do as well, to try and address the needs of the individual organization. There are some common provisions we put in, and we have some language that we commonly include, but we try to adapt it to what they're talking about. The purpose, we used to always put a purpose clause in saying, hey, this is what this LLC is going to do, but they can also do any other lawful activity. Well, from time to time, we have put a limited purpose clause in. It restricts the LLC to certain limited activities. We've done that because we deal with serial entrepreneurs, and they got a bunch of different things going on with different people. And, the seed clinic doesn't try to compete with law firms. We try to avoid that at all costs. Instead, we try to deal with people who can't otherwise afford lawyers. But we do deal with a bunch of students who have a bunch of different irons in the fire, and we want to define this LLC is their vehicle to do this. Particularly with tech people and software people, they have a bunch of different things going on. We're not going to say they do anything else. We don't want there to be any confusion that this is the entity that X has to do this certain purpose. And the members of this entity can't claim they're involved with some other endeavor that the person has. So we're trying to define this is this certain entity. So we may do a limited purpose clause, but still allow flexibility. We're not going to hone them in to this is exact specific thing that they can do and nothing else. We don't want to be that limiting. Membership is always an interest. Who's going to sit at the table? Is it going to be by majority or unanimous vote? I think this is one of the key things in the organization. It's usually a unanimous vote, but we talk to them about that. We deal with people sometimes who are 50-50 owners in terms of the membership. Majority doesn't change or unanimous vote doesn't change for them, but we see from them unanimity can be a good thing. Some friends of mine set up a business that's been fantastically successful. Two of them owning an equal ownership interest. And eventually what they found was, hey, one of us has to give way, and we may have to have somebody mediate disputes between us, and we may have disagreements, but that's sound for us. One has to agree, or one has to just drop it. In terms of meetings, none are required by the Ohio Revised Code. With a corporation, you're supposed to have an annual meeting, and that's kind of common with LLCs to have an annual meeting. But there also may need to be a procedure to call a meeting. Some I've seen have quarterly meetings, particularly where somebody's not involved in the day-to-day business, but instead is sort of more of a passive investor. How to end the membership is, as I mentioned before, sort of one of the primary issues. We often put a right of first refusal. If somebody wants to sell their interest, they can sell it to someone else. And then the trick is, how do you value it? Or unanimous consent for transfer to a non-member. That's common. Or the revised code would let, one of the things that the revised code does is say, hey, they can sign or transfer their membership fairly readily. So this is one of the things that people worry about. Sometimes they get a full membership interest voting in economic. In some agreements say, hey, if you sell it to somebody else, they only take an economic interest. They get the same distributions as everybody else, but they don't get to vote in matters. The problem with that is, it devalues that interest. It hurts the person that's selling because somebody wants the full voting rights and everything else. But keep in mind, the membership interests are not as readily transferable as stock in a corporation. And that's why, when people are out seeking venture capital, they tend to have a corporation. But we need to deal with the membership interest. If somebody wants to withdraw or sell their interest, usually we give pretty good notice period, 60, 90 days. And it's good to set all these rules in place before the members know who is going to do what, and they're not faced with this crisis. They're more objective. They look at it, well, 60 days, 90 days doesn't sound that bad until they want to move to California and they need the money and all that. So the required notice is, something I think that to set the rules up front makes a lot of sense. Valuing the member's interest is very difficult. My preferred method, and I think our preferred method in the Seed Clinic, is to have an accounting firm valuation service value the interest. But with a lot of our little startups, it's just not practical. They don't, they have $2,000 in assets, and they don't want to spend $1,000 with an accounting firm to value what they have. And I think most of you know this, a pre-revenue business is very difficult to value. It's not a science. It's very difficult. So valuing the interest is difficult. And then the question is, are we going to distribute assets or money? I can't tell you how many times we've let some member out or bought them out by giving them a laptop. That's just what these students have and what they want and what they value. Usually we're paying, but sometimes there is this laptop transaction or something else they want. Also, the question is there a remedy for breach of the operating agreement? If they're supposed to be active in the business and they're not, how do we remedy that? And we tend to put clauses in that deal with that. Buyouts. The statutes provide that it's required upon the member's withdrawal. Membership is terminated if the member files for bankruptcy or makes assignment for the benefit of creditors. That may not be the case, what you want in terms of situations. If an individual files for membership, you may not want to end um, that person's interest in the company. Um, and so we may have buyouts, mandatory or optional in those circumstances or other circumstances. Um, and as I mentioned, it's difficult to determine the purchase price. Is there a market value? These things are readily sellable to somebody. Somebody may want to buy the interest in the LLC, but because they're involved in the organization or they have dealings with them, but that's not always the case. We have tried to come up with some book value kinds of things in operating agreements, but they're difficult. A formula based upon gross or net sales, um, or some of the financials where we look at the liabilities opposed to the assets, and this idea of an appraisal or evaluation by accounting firm or some other entity. Um, Also, it talks about the method of repayment. Um, the LLC probably cannot afford a huge slug of money to buy somebody out, so it may want to pay them out over time. And that's not uncommon for us to string payments out over a year or maybe even a longer period of time. And that's something you certainly can do in an operating agreement. Management is uh, member managed typically, and the ones we deal with, it's like a partnerships. Members are in control, but the operating agreement can limit what they can make decisions on, what they can do on their own. Manager managed larger, well-funded entities typically may hire somebody to be the CEO, to be the manager, and then limit the authority of members to buying the LLC. We tend to limit them to purchase. Oops, I went too far. Yeah, I don't know how to go back. Okay. Oh, here we go. Um, we tend to limit the ability to bind. Um, we may limit their ability to sign contracts. A lot of times they're retaining independent contractors to do some functions. Um, for transactions above a specified amount, you can't purchase anything above $1,000. We want it. The trick is to give them enough authority they can exercise on a day-to-day basis to buy things and make transactions that they need to do, but not the out of the ordinary things. And often it is that we do provide for the use of a mediator, a third-party advisor, not us typically, but some business advisor to help with some of these things, to discuss when they need to come for a vote. Voting, unanimous or majority, and new members are usually unanimous. Transfer of interest, members' resignations, distributions, manager changes, all these different things. Um, are we going to make it merely a majority? If there's 3 people, can 2 of them control it? Or does it have to be unanimous? The problem often is with unanimous that one person can become a malcontent and holds up everything, and the LLC can't function. So we try to not have everything unanimous, sort of divide between the two depending upon the need for quick action. Typical in an operating agreement is a listing of capital accounts, their initial capital contributions, what they've contributed to the business. It may be straight money, it may be some equipment, it may be different things. We try to detail the contributions and talk about allocations and distributions. We also tend to um, deal with the tax issue. An LLC can be either taxed as a partnership or a corporation. You would think you wouldn't want the double taxation of a corporation, but in certain circumstances, because of self-employment taxes, depending upon what the LLC does, it can be to their benefit. Usually, they would make the election to be taxed as a partnership. Ownership, typically, we give people percentage interest. This person has 20%, this person has 10, 15, whatever it is. The idea is that then, somebody's later interest isn't benefiting more than the existing members. They'll be impacted, and they may be diluted as more people are joined as members, but if the percentage seems to keep people proportional, and that's generally how this is handled. As I mentioned, cash contributions can be cash, property, services. One of the big issues we run into too is sometimes we say there may be future contributions. If that's required and somebody doesn't make the contribution, what happens? I have seen operating agreements where it says that at that point, the person is out and loses their complete interest in the company. Well, I don't think that's legal at all. They had something, you just can't take it away. They had property, you can't take it away. I think the penalty generally is if they don't contribute, they lose, from a percentage standpoint, their interest in the company. If two of the members contribute an additional $10,000 and one does not, you have to reflect that in terms of their percentage interest in the company. They're gonna lose ground in terms of their percentage of the company, and that's what normally we would specify. Allocation of profits and losses. The statutes say generally it's based upon the corporate records, their capital accounts, the value of record, the revised code talks about. And so that would be their capital accounts. And that often isn't kept up to date. So that's a problem. An operating agreement gives you the benefit of giving an equal distribution to everybody based upon their percentage of ownership. And some people even forego distributions. One of the things too, and I thought I had a slide, maybe it's coming up, I'm trying to finish this quickly, is many entities, they have, somebody contributes much more money up front. And sometimes we document that with a promissory note and make it a loan, and there aren't any distributions until that loan is paid back, or there's reduced distributions until the loan is paid off, and more money goes to that payment of that note. Oh, there's the loan bullet. Distributions, generally we don't provide that they're going to be at any particular time. Some LLCs, and I've been involved in some, do make distributions at the time that taxes are due. So if you're receiving, if you're going to have to pay some taxes based upon, the LLC's value, you will have the money to pay the taxes. Some want to set aside a certain percentage of profits to build up the business by reinvesting and saying no distributions until after we hit a certain mark. Loans paid before profits, I mentioned, and our distributions, do they require a vote or not? And that's all part of this. Dissolution. Usually it's unanimous. There are certain statutory events. Withdrawal of a member is supposed to dissolve the LLC, and that's not what you usually want. So you want an operating agreement to provide for that. There can also be judicial dissolution. So we tend to specify a vote, and it may be unanimous to dissolve, rather than just leaving the statutory events. I think that's it. There's our plug for the seed clinic. I'd open it up for questions or comments. We want to keep these short to a half an hour or so, but we can certainly run over a few minutes. Anything for the good of the order?
Gary?
Yeah.
Tom here. Quick question. Do you ever deal with death and divorce as far as transferring your shares?
Yeah, and
Not that those two are the same thing.
Well, well, they're bad, both of them. Yeah, we typically do, specifying what happens in those situations, particularly a death. Is the person's interest going to go to some heir, and or are we going to value that interest and pay that into the estate? Those, typically people who are dealing with one of the parties to a marriage don't want to end up dealing with the other, and in a death or a divorce. So we put a provision in that provides for payment. Now, I've always had some concerns. Typically, we pay over time. I think that's fine, but I would just wonder if somebody could say, hey, upon the death, we need to wind down the estate. You should pay it all into the estate now.
Hey, Gary, this is good. Let me see if I can just get Melissa's attention. Your camera's on. I don't know if you want it on, so I just wanted to check with you about that. And your refrigerator's open, so go ahead, Gary. Sorry about that.
Fine.
Pizza for lunch.
There you go. It's lunchtime almost.
That's terrible. Okay.
Tom, I hope that answered your question.
Yeah, I mean, I have dealt with that. I know courts at times thinks they can overrule operating agreements or shareholders agreements, and becomes a problem. The other thing I'm looking at, do you put you talked about you can't take away people's interest. I have found that I can put a penalty in for non-contributions on a cash call.
Right. On a cash call, we put that in. Typically, we put a penalty that they're diluted more than just not making the cash call. Yeah. I assume they can agree to some other penalty. I'm not even sure what that would be. That's the only one that really comes to mind.
Feathering sounds good sometimes.
Well, yeah. I don't know if it would make a difference to anybody, but some kind of diminished title or diminished role, maybe. Tom, too, we get into this. Some of them are working in the business and then they walk away from it because they take other employment or they move or whatever. And what happens in that situation too? It's almost akin to it. You were making this contribution and now you're no longer making this contribution. And we struggle with that. I don't think we have effectively dealt with it in many of our operating agreements. We don't anticipate it. The parties don't anticipate it. And then it's an event. The option is to buy them out or just let them passively remain.
Once again, valuation and price is the.
Yeah, and if anybody ever comes up with a good way to value these little.
I got a great one. On a two-person LLC, I got a great one. I used it a lot. The Chinese fortune cookie. Chinese cookie.
I know what you're talking about. Yeah, I've always heard of it, and now I'm not sure it's appropriate to say that.
One person sets a price, the other person
the auction
by herself. Yeah.
Yeah.
I mean, I've used it very successfully in young 2-person, whether it's corporation or LLCs.
Yeah, yeah. I'll buy it for this. Will you?
Yeah,
Essentially,
you choose. I'll set a price. You choose buy or sell.
right. Yeah, and I have used that more as a fallback with a 2-person, not so much putting it in the operating agreement.
No, I use it as a threat.
Yeah, yeah, is a dispute resolution. Anything else for the good of the order here? We are trying to hold these to close to half an hour, and but we want to answer any questions you may have. Um, we probably should have put Doug's name up there too.
No, I like it just like it is.
Yeah, you want me to get all the emails.
Yes, sir.
Well, that's fine. We're here to help you. Now, we're coming up on a period of time where we're going into finals and we won't have students here for a while, but we want to help the different universities and the different entities with their needs. Potentially in late December we could, but certainly in January, we're going to have a full boat of seed students and people that we can throw at these projects and then supervise. Doug's expertise, just so you know, he was a vice president of a major corporation, and he has IP experience. And we're not looking to do patents for anybody, but we will have a student who is a patent agent, and we're looking to give IP advice here in the coming semester. And with the next presentation we're talking about doing is Doug talking about copyrights. And we're looking for times that would be good for that. I'm not sure Friday morning's the optimum. We're thinking about doing it in December. I don't know if anybody has any thoughts about when is a good convenient time to pull in a bunch of people. Please let us know. We thought Friday mornings might be good because there's not a lot of classes on Fridays, but maybe that's not the case. Doug, do you want to talk a little bit what you're anticipating with the copyrights, and then we'll turn everybody loose?
Yeah, so we got it in our survey. We got a pretty healthy response that intellectual property was an area that folks were interested in. More background, more counseling in that area. And you can't, in the course of a 20-minute or so talk, you can't traverse all the areas of intellectual property. But I think copyrights is really a unique one. And we've got quite a response from Kent State, as we've reached out to them. So copyrights apply to design works and artworks and photographic works. It applies to writing code and things like that. It applies to publications that you may make to support your business. And so, we think, tune-up session on how to copyright, how to give copyright notice, how to enforce your claim, when you would decide to register a copyright would be beneficial to the educational community. And we'll go from there. We can talk in a future sessions about patenting or trade secrets, or again, whatever the interest of our community would like to hear.
Right, and we're looking at doing that in early December, the week after Thanksgiving. So.
Any more on days of the week? I really am curious. I wonder if we've really, most people don't want to meet on Fridays. I know Friday afternoons would be bad, but I just kind of like to hear from anybody who's gotten a feeling on that.
Maybe we need to send out another survey monkey or something.
Okay, very good.
All right, so we are going to send the recording of this out to you and to others. So. It'll catch my fumbling and bumbling around, but hopefully it'll be a resource that people can use. And in the meantime, if you have any question, reach out to us. Everybody stay safe and hopeful. We're going to, here's somebody asked, are all the services of the Seed Clinic available to students of the EEC group? And that certainly they are. We used to charge a standard fee to people, but now we are under this Burton D. Morgan grant. And anybody from a Northeastern Ohio University program, entrepreneurial program or business program, um, we will help them for free with their startups. And we do it pretty promptly. They will be working with law students, and then Doug and I will supervise the work, and we get good results. Sometimes we're not as fast as law firms, but we do have the ability to get a good product to them. Any other questions?
Yeah, this is Mary.
Yeah.
I just wanted to clarify just on that last point. When you say services, are you referring both to these prepackaged kind of educational content recordings as well as the one-on-one individualized assistance?
Yeah, thanks. That's a good question. And yeah, we're talking about giving them these sort of mini sessions that hopefully they can use in a class or with people that have questions on the subject of like operating agreements. But we do also want to work with all these different universities and their startups. So that's what I was more referring to with the fee basis was the startups. At some point when we come out of this pandemic, we're looking that we would like to go to the universities and maybe have office hours there. We're doing a lot of it now on Teams and so forth. But the idea is we're going to try to better serve the entrepreneurial classes and the startups and student startups. So we're trying to reach out more.
Yeah, and I think it'll be a matter of depending on what kind of response and influx you get, we certainly can't probably serve the entire region all at once. I think, a slow rollout for those more high touch individualized services is kind of what's being worked on with the law students. Is that?
Yeah, exactly. Yeah,
Okay.
exactly. Yeah, we're going to try and go to a few schools to start, and we're even during the pandemic we're doing it remotely, but we do want to get more engaged, and for years we went to Youngstown State University and dealt with some people at their business college, and we dropped it in the last few years, and now we want to get back to that and do certain things like that with others. With other universities. I saw a chat too. Somebody wanted to know if they could have the slides. We'll send the slides. And hopefully, Doug, you kind of kept track of who everybody's in here. I think we'll send it to everybody we invited, the slides and the recording. So we'll send them out. Anything else for the good of the order?
Gary and Doug, thank you.
Well, thank you. Thanks to everybody for joining us. Stay safe and hopeful. We'll sign off now.
All right.
Thanks. Take care.
Thanks, Gary. Thanks, Doug. Bye.
Thank you.